Hi guys, welcome back to Battle with Ola. This is Mujula, and today I want to quickly talk about force majeure. But before I go into it, I want to thank a very huge fan of Battle with Ola who sent me some money, the other week. It was unexpected, and I'm really grateful. Thank you so much for your support, all this time. Thank you. If you watch this video till the end, I would explain how you can support the channel and some other benefits that you are probably sleeping on that you should harness from the channel. So let's go right into force majeure. What is force majeure? Force majeure is usually used in contract, law of contract. It is a term that signifies something that happens beyond human control. So we describe it as irresistible force, or something that is not contemplated, that takes place, which then makes it impossible for the terms of a contract to be fulfilled or carried out by a party or both parties. So force majeure can take different forms. It could be a riot breaking out. It could be an epidemic. It could be war. Or it could be crime or some other, maybe weather change or a natural disaster that is not preempted or expected. So there's a difference, and I'll give 3 instances where force majeure will not hold. But before I jump the gun, what it simply means is that when any of these things that I've stated or any other thing or acts that, passes for force majeure, when they take place or happen, a party can rely on them to be excused from their obligation under a contract. So let's say Mr. A and Mr. B signed a contract, for instance, to do so and so within so and so time, and there's been consideration that is maybe an exchange of value payment made for services that are to be rendered, and then something happens which prevents a party from carrying out their own part. Maybe they've collected the money, but something occurs that makes it impossible for them to render the service for which they've been paid, or something else happens on the side of the other party. If it qualifies for force majeure, they will be excused. If you follow legal trends, I know that in Nigeria, a lot of people were talking about force majeure during the COVID-19 lockdown. Yes, COVID-19 passes for force majeure because it was an epidemic, or will I say, an epidemic, an outbreak, and unexpected because, we had literally never seen anything like it. I know that, medicine traced it to, some old period in time when something like that happened, but essentially it was not preempted. It wasn't something that we could foresee. It wasn't something that we could predict and say that, oh, it's going to happen at this time, so we're going to make preparations for it. No, it was something that caught the world unawares. So it passes for force majeure. And if any person's contract was interrupted because of that, they might be or might not be excused from the obligations of the contract, depending on how the contract is worded and how it's couched, and the interpretations that they seek or they give to it. So usually it is included. It is a very important clause in a contract. Please watch the video that I made on contracts and important terms of a contract. So it's a term that must be contained in a standard contract to say that in the event of force majeure, this and this should happen or will happen to parties. So if a situation or a condition can pass for force majeure, a party would be excused from the obligation. For instance, if people have bought tickets to a music show or a concert, and then there's a flash flood in that area that was not expected. That area is not a flooded area normally, but now there's been a flash flood and people had to be evacuated. The concert was disrupted and things could not go on as planned. You cannot hold the concert organizers or the artist or something and say that, oh, restore us to status quo ante bellum, that is, give us our money back, re-sign the contract, take us back to as if we never had a contract, because when you pay and they offer you a concert, that's a contract really. So you cannot place that kind of demand because that flash flood is a force majeure. So what are the 3 instances where force majeure will not hold? The first instance that I want to talk about is malfeasance or negligence. You know what negligence is. I've done a video on negligence, or even 2 videos, and you know what malfeasance is. Malfeasance just means that you do something to injure another party in a contract. For instance, if you've been engaged to provide food for a party, a birthday party, for instance, and then it's a children's party, and then you have provided, you have brought food that can poison the children. You have cooked the food in such a way, maybe you undercooked it, and the children get food poisoning as a result. That's malfeasance on your part. Probably because you were trying to save money on gas used to cook, or maybe you were trying to, save money on some other, equipment or ingredient, and then you undercook the food and the children get food poisoning. That's not an act of God. That's not an irresistible act. That's not an unforeseeable act. It is foreseeable that if you undercook food, it can lead to food poisoning. So that's malfeasance. Negligence would be that maybe you have cooked a fish stew, for instance, and you have not taken, the care, to maybe debone the fish. Maybe it's a, you have, crumbled the fish into the stew, and you're giving it to toddlers, to infants. Toddlers, now let's use toddlers. And you have not even taken the pain to remove the bones. You are predisposing them to harm, because at that level you owe them a duty of care. They cannot debone, their own fish, their own stew. You owe them the duty of care if you're providing food for their party or something. Maybe to alert their caregiver that, oh, there's so and so in the food, or to even remove it before you serve it to them. So that would be negligence. So in those instances of negligence, of malfeasance, force majeure will not avail a party. So it must be clear that this is an act of God, that it was unforeseeable, and that there was nothing humanly possible that could have been done to avert or prevent it before force majeure can avail a party claiming it in court. The second instance is any consequence of a usual or natural force. So force majeure will not avail you for things that happen according to their natural occurrence, or maybe a usual occurrence. For instance, let's use the concert example. Let's say that it was a rainy season, and you have not provided maybe canopies for concert goers or your concert attendees, and then it rains, the concert is disrupted, people have to run home, maybe people get accidents, things happen. That contract of providing the service of a concert in exchange for money's paid for tickets, that's a contract. So you cannot claim force majeure in that instance, because rain was expected in the raining period, and you should have preempted that and made provisions, adequate provisions. So force majeure will not hold in that instance. So sometimes force majeure can be very controversial, in the sense that some cases are borderline. For instance, in the rain example I gave, maybe you were expecting light rain and you had made provisions maybe for some canopies, and then it turns out that it's heavy rain, a storm, a thunderstorm, and all of that, and then even maybe the canopies were blown off and all of that, people get injured, the concert is disrupted and different things happen. Force majeure might hold for a party that is claiming it in that instance, because yes, you expected rain and you got canopies, and maybe you made available some other things, maybe umbrellas for attendees and all of that. But now, instead of just normal rain, maybe light rain, you have a thunderstorm, you have heavy rainfall, with storms and everything. So force majeure might hold if you're able to convince the court and distinguish the circumstances. It's important to have that in mind. And then the third instance is where the contract has already outlined certain occurrences. So I said that an epidemic passes for force majeure, but if the contract has already contemplated an epidemic and it has already said that in the instance of an epidemic this and this would happen to parties, a party cannot come and claim force majeure, because the contract has already stipulated what will happen in the event of an epidemic. So yes, I said that in cases of negligence and malfeasance, in cases of a contract stipulating already what should happen in such instances, or a contract that has already contemplated some circumstances that should naturally have come under force majeure, what the contract has contemplated will come to pass or will hold. And I've said also that in the event, that what has happened is the natural course of events. Rainfall is an external force. It's an act of God, but it is an act of God that's predictable to, great lengths. You can often say that, oh, it will rain at this time, it will be this heavy or that heavy. But in the instance that though it is predictable, it's a natural or a usual occurrence, the outcome was not predictable, force majeure might still hold. So in this video, we talked about force majeure. We've talked about it being an act of God, being something that is beyond human powers, something that happens by an irresistible force, and it's a contract clause that excuses a party from their obligations under the contract, their normal obligations, under force majeure, if they claim force majeure and the court holds it for them. That's all I have for you in this video. If you have any questions or concerns, or you want to continue the conversation, leave them in the comment section or mail me at houseoflivingstones@gmail.com. How can you benefit more from this channel? I have one-on-one consultations, paid consultations that you can sign up for. If you have a legal dilemma or challenge, I will consult for you, tell you what you need to do, the options that are available to you at a fee. Yes. And if you have a question that which answer can generally benefit people, not something that is particularly tailored to you, you can shoot me a mail at houseoflivingstones@gmail.com for free. And I might make a video on it, or I might just answer you directly. But if it's something which answer needs to be particularly tailored to you, you should totally sign up for a consultation. The link to sign up is in the description box. And of course, you can always like the video. Very important. That way, the duty is on YouTube to circulate it and not on you. And of course, you can also join the channel for a token to enjoy more benefits. And you can subscribe for free. So many things that you can do. I will see you in my very next video. Toodles.